Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People ex rel. Neville v. Toulon decided October 22, 2024. Singhas, J. This appeal requires us to examine whether certain provisions of Mental Hygiene Law Section 10.11, d. 4, satisfy procedural due process. Those provisions govern the procedure for the temporary confinement of sex offenders adjudicated to have mental abnormalities but released from confinement to strict and intensive supervision and treatment, SIST, pending the final SIST revocation hearing. In particular, Section 10.11, d. 4, permits pre-hearing confinement upon a prompt judicial finding of probable cause to believe that the respondent is a dangerous sex offender requiring confinement. We conclude that the current statutory scheme appropriately balances the relevant individual and state interests and provides sufficient process to mitigate the risk of erroneous confinement without a respondent's participation at the probable cause stage. Thus, we hold that petitioner has failed to demonstrate that Mental Hygiene Law Section 10.11, d. 4, is unconstitutional on its face, or as applied to him. 1. In 2007, the legislature passed the Sex Offender Management and Treatment Act, SOMTA, creating a program to closely supervise and treat sex offenders who are near release from prison or parole who possess mental abnormalities that create a substantial risk of committing new sex crimes. Pursuant to SOMTA, which is codified as Article 10 of the Mental Hygiene Law, every detained sex offender's case is reviewed by the Office of Mental Health, OMH, which then refers some offenders to a case review team, which may arrange for psychiatric examination. Mental Hygiene Law Section 10.05, d. e. If the case review team determines that the offender is a sex offender requiring civil management, meaning they suffer from a mental abnormality, the case is referred to the Attorney General for possible litigation. A mental abnormality is a congenital or acquired condition, disease, or disorder that affects the emotional, cognitive, or volitional capacity of a person in a manner that predisposes them to the commission of conduct constituting a sex offense and that results in that person having serious difficulty in controlling such conduct. If the Attorney General concludes that the offender's case is appropriate for civil management, they may file a petition seeking such management, id. Section 10.06, a. After additional psychiatric evaluation, and within 30 days of filing the petition, the court must hold a hearing to determine whether there is probable cause to believe that the respondent is a sex offender requiring civil management. If the court finds no probable cause, it must dismiss the petition. If probable cause exists, the court must order that the respondent be committed to a treatment facility upon their release from prison or parole and must set a date for trial within 60 days. At the trial, the Attorney General bears the burden of proving by clear and convincing evidence that the respondent is a detained sex offender who suffers from a mental abnormality. If the jury unanimously determines that the Attorney General has sustained their burden, then the court must conduct a separate dispositional hearing to consider whether the respondent is a dangerous sex offender requiring confinement, i.e., they suffer from a mental abnormality involving such a strong predisposition to commit sex offenses, and such an inability to control behavior, that the person is likely to be a danger to others and to commit sex offenses if not confined to a secure treatment facility or a sex offender requiring SIST, if, after the dispositional hearing, the court finds by clear and convincing evidence that an individual meets the criteria in Mental Hygiene Law Section 10.03, e. Then the court shall find the respondent to be a dangerous sex offender requiring confinement, and the respondent shall be committed to a secure treatment facility for care, treatment, and control until such time as the respondent no longer requires confinement. Article 10 requires at least annual evaluation by a psychiatric examiner to determine whether the respondent is currently a dangerous sex offender requiring confinement. Respondents found to be dangerous sex offenders requiring confinement also have the right to annually petition the court for discharge, pursuant to which a court must conduct an evidentiary hearing at which the Attorney General bears the burden of proof. Moreover, If OMH determines that a respondent is no longer a dangerous sex offender requiring civil confinement, it must petition the court for discharge or release to SIST. The respondent may at any time petition the court for discharge and/or release to the community under a regimen of SIST. If the court determines that the respondent is not a dangerous sex offender requiring confinement, then the court must release the respondent to SIST. Before release, the Department of Corrections and Community Supervision, DOCS, recommends supervision requirements that may include but need not be limited to electronic monitoring or GPS, tracking for an appropriate period of time, polygraph monitoring, specification of residence or type or resident, prohibition of contact with identified past or potential victims, strict and intensive supervision by a parole officer, and any other lawful and necessary conditions that may be imposed by a court. The court must then enter an order specifying the respondent's SIST conditions, including supervision requirements and compliance with a specified course of treatment. This appeal concerns the initial step in the process for revoking SIST. If a parole officer has reasonable cause to believe that a respondent has violated a SIST condition, or if an evaluation or report by a treating professional indicates that the person may be a dangerous sex offender requiring confinement, a parole officer may take the violator into custody and transport them to a facility for a psychiatric evaluation, which must take place within 5 days. Once the violator is taken into custody, DOCS must promptly notify the Attorney General and the Mental Hygiene Legal Service, MHLS, which provides legal representation to Article 10 respondents. The Attorney General may then petition for confinement or petition to modify the conditions within 5 days. The petition must be served promptly on the respondent and MHLS, and the court must appoint legal counsel to represent the respondent and provide counsel with a copy of the psychiatric evaluation. If the Attorney General files a petition seeking confinement, then the court shall promptly review the petition and, based on the allegations in the petition and any accompanying papers, determine whether there is probable cause to believe that the respondent is a dangerous sex offender requiring confinement. Upon the finding of probable cause, the respondent may be retained in a local correctional facility or a secure treatment facility pending the conclusion of the proceeding. Within 30 days of the petition seeking confinement, the court must conduct a hearing to determine whether the respondent is a dangerous sex offender requiring confinement. At this final revocation hearing, which is conducted in accordance with the same procedures as the initial dispositional hearing, the respondent may offer evidence and present arguments. Any failure to commence the hearing within 30 days shall not result in the dismissal of the petition and shall not affect the validity of the hearing or the determination. The respondent shall not be released pending the completion of the hearing. 2. In 2006, Ralph S. was convicted of first-degree sexual abuse and sentenced to a period of incarceration. Prior to his release, in 2010, the Attorney General filed a civil management petition pursuant to Mental Hygiene Law Article 10 and, after a trial, a jury found that Ralph S. had a mental abnormality. After a dispositional hearing, Supreme Court determined that he was a dangerous sex offender requiring confinement and ordered him confined. In 2016, Supreme Court determined that Ralph S. no longer required confinement and transferred him to SIST. As conditions of SIST, Ralph S. agreed to, among other things, abstain from using or possessing alcohol, wear an alcohol monitoring bracelet, and not tamper with that bracelet. In December 2019, Ralph S.'s parole officer charged that, on several occasions that month, Ralph S. had tampered with his alcohol monitoring bracelet to conceal his use of alcohol in violation of his SIST conditions. The parole officer deemed the violations concerning given the connection between his alcohol use and his prior sex offenses, and his failure to be forthcoming regarding his use of alcohol/tampering with the alcohol monitoring device. Ralph S. was taken into custody on December 19. 2 days later, an OMH psychologist interviewed Ralph S. while he was in custody with his MHLS counsel present. On December 23, the OMH psychologist issued her report concluding that Ralph S. was a dangerous sex offender requiring confinement based on her diagnoses and the circumstances surrounding Ralph S.'s SIST violation. The report indicated that, given Ralph S.'s reported connection between his alcohol use and his sex offenses, including informing treatment providers that if he began drinking again, he would re-offend, the nature of his SIST violation presented a heightened risk of reoffense. 5 days after he was initially detained, on December 24, the Attorney General filed a petition to revoke Ralph S.'s SIST regimen and transfer him to secure confinement. The violation report and the OMH psychologist's evaluation report were attached to the petition. The same day, Supreme Court reviewed the petition and accompanying documents and determined that there was probable cause to believe that Ralph S. was a dangerous sex offender requiring confinement. The court therefore ordered Ralph S. detained pending the final SIST revocation hearing, which it scheduled for January 15, 2020, 28 days after he was taken into custody. His attorney subsequently requested and was granted an adjournment until February 26 to have additional time to obtain an expert report. On January 31, after his counsel had requested the initial adjournment, but before the adjourn date, Ralph S. filed a habeas corpus proceeding against OMH and DOCS. He argued that Mental Hygiene Law Section 10.11, d. 4, violates procedural due process because it does not provide notice and an opportunity to be heard on the issue of whether there is probable cause to believe that the individual alleged to have violated their SIST conditions is a dangerous sex offender requiring confinement. At oral argument on the habeas petition, his counsel advanced the same argument. After the hearing, Supreme Court denied the petition, and Ralph S. appealed. The appellate division converted the proceeding to a declaratory judgment action and declared that the relevant statutory provision did not violate Ralph S.'s right to due process. Initially, though the appeal was academic because Ralph S. had been released back to the SIST regimen, the court determined that conversion to a declaratory judgment action was appropriate because the exception to the mootness doctrine applied. See People ex rel. Molinaro v. Warden, Rikers Island. The court rejected Ralph S.'s facial challenge, concluding that in at least some circumstances, the statute sufficiently protects respondents' liberty interests from erroneous deprivation and provides them procedural due process. The court also rejected his as-applied challenge, insofar as it was preserved. Petitioner appealed as of right, CCPLR 5601, b. 1, 3. It is well settled that legislative enactments are entitled to a strong presumption of constitutionality, Dalton v. Pataki, quoting Schultz v. State of New York. Courts strike them down only as a last unavoidable result, matter of Van Berkel v. Power, after every reasonable mode of reconciliation of the statute with the Constitution has been resorted to, and reconciliation has been found impossible, matter of Fay. A party advancing a facial challenge bears the burden to demonstrate that in any degree and in every conceivable application, the law suffers wholesale constitutional impairment, Cohen v. State of New York. Regarding the statutory scheme at issue here, it is settled that a state may use civil process to confine a sex offender for treatment of a mental abnormality, that makes it difficult, if not impossible, for the person to control their dangerous behavior. Kansas v. Hendricks, upon proof of serious difficulty in controlling behavior, Kansas v. Crane. Due process does not require states to provide supervised release for any sex offender who is found to possess a mental abnormality, see Hendrick. However, state statutes may create liberty interests that are entitled to the procedural protections of the Due Process Clause of the 14th Amendment, Vitek v. Jones. The state does not challenge petitioner's assertion that release of a sex offender requiring civil management to SIST creates such a liberty interest. The due process clauses of the 5th and 14th Amendments, as expressed by the Matthews v. Eldridge balancing test, govern the scope of procedural due process in civil confinement proceedings, matter of State of New York v. Floyd Y. Due process is flexible and calls for such procedural protections as the particular situation demands, Matthews, quoting Morrissey v. Brewer. Thus, courts must consider three factors to determine the dictates of due process in a given context: 1. The private interest of the litigant. 2. The risk of erroneous deprivation in the absence of substitute procedures, and 3. The state's interest in avoiding additional procedures, Floyd Y. Petitioner contends that an adversarial probable cause hearing, where an individual is allowed to present evidence and make arguments, is necessary to protect the procedural due process rights of those subject to confinement pending final SIST revocation hearings. We disagree. A. Freedom from physical restraint has always been at the core of the liberty protected by the Due Process Clause from arbitrary governmental action, Hendricks, quoting Futcha v. Louisiana, see Floyd Y. However, at the point of a SIST revocation proceeding, a jury has already determined after trial that the individual possesses a mental abnormality. This finding that the respondent has a condition, disease, or disorder causing them serious difficulty in controlling their predisposition toward conduct constituting a sex offense, entails extensive due process safeguards, including requiring a unanimous jury verdict, imposing the heightened standard of proof by clear and convincing evidence, and placing the burden of proof on the Attorney General. Mental Hygiene Law Sections 10.03, I, 10.07. Here, our focus is on the limited statutory liberty interest created by the court releasing a respondent to SIST after the jury's unanimous verdict of mental abnormality. The relevant consideration is the nature of that interest, and the degree to which confinement upon a showing of probable cause infringes on it. At the outset, by statute, a respondent's release to SIST is expressly subject to revocation upon a determination that the respondent is a dangerous sex offender requiring confinement. Moreover, the statute does not contemplate indefinite detention based on the initial probable cause finding. The mental hygiene law provides that a SIST revocation hearing must take place within 30 days of a confinement petition. Thus, we conclude that SIST revocation respondents possess a diminished and temporary physical liberty interests implicated by the court's probable cause determination. B. Second, the degree to which an adversarial probable cause proceeding would provide additional protection against erroneous probable cause determinations is minimal. At the outset, the statute's requirement of an independent judicial probable cause finding provides a significant safeguard. To sustain their burden, the Attorney General must present evidence sufficient to support a reasonable belief that the individual has such a strong predisposition to commit sex offenses, and such an inability to control behavior, that the person is likely to be a danger to others and to commit sex offenses if not confined to a secure treatment facility. Indeed, courts have held that judicial probable cause determinations provide substantial procedural protection, even absent an opportunity to be heard, compare Gerstein v. Pugh, holding that an ex parte judicial hearing on the issue of probable cause for pretrial detention under the Fourth Amendment provides meaningful protection from unfounded interference with liberty, with dissenting op. at 9, contending that an independent judicial probable cause determination does not constitute even minimal pre-deprivation due process. Moreover, a respondent plays some role in the determination, insofar as the psychiatric report that forms the basis for the revocation petition must be prepared based on an interview with the respondent, often with counsel present. And the statutory scheme provides for a respondent's participation at a full revocation hearing to be held within 30 days of the petition, allowing the respondent to present evidence and raise arguments at a full hearing on the relevant factual and legal issues, at which the state's burden of proof is considerably higher. Against this backdrop, the level of added protection in adversarial preliminary hearing would provide a slight and case-dependent. Probable cause does not require the fine resolution of conflicting evidence that a reasonable doubt or even a preponderance standard demands, and credibility determinations are seldom crucial in deciding whether the evidence supports a reasonable belief. Gerstein. Courts are well equipped to engage in a straightforward probable cause analysis without adversarial presentation, and there is no evidence that courts frequently make erroneous probable cause determinations without respondents' participation. Petitioner has not otherwise demonstrated that the current scheme leads to incorrect probable cause findings, or that a respondent's participation would meaningfully reduce the instance of such errors. Conversely, allowing a respondent's full participation in an initial hearing could undermine the statute's requirement of an expeditious probable cause determination. In the present case, the statutory procedure enabled Supreme Court to make a probable cause determination the very same day the Attorney General filed the SIST revocation petition, ensuring that Ralph S. was afforded court process within 5 days of his initial detention. Affording respondents an opportunity to collect and present evidence and file papers would inevitably delay such determinations, resulting in a longer period of confinement without the benefit of this initial process. C. The final factor, the state's interest in avoiding additional procedures, weighs heavily in the government's favor. The state's interest in protecting the public is significant. Upon a SIST violation and a psychiatric examiner's determination that an individual is a dangerous sex offender requiring confinement, the state has a strong interest in moving expeditiously to ensure that the respondent, who has been shown to be a serious threat to public safety, is removed from situations where they may harm members of the public. Requiring adversarial proceedings prior to confinement, even after a psychiatric professional has determined that a respondent is a dangerous sex offender requiring confinement, could pose a serious risk to the public. Conversely, as explained above, confining a respondent pending the outcome of preliminary adversarial proceedings would result in longer confinement before any initial process, undermining the state's interest in knowing early on whether its grounds for pursuing confinement are mistaken or unfounded. D. Balancing the Matthews factors, though SIST revocation proceedings implicate a diminished physical liberty interest, the relatively short period of confinement before a final hearing, the minimal benefit of an adversarial proceeding, and the state's paramount interest in protecting the public lead us to reject petitioners' contention that the court's initial probable cause determination must take place as part of an adversarial proceeding in order to comport with procedural due process. The procedures outlined in Article 10 appropriately balance the need to safeguard respondents' due process rights by prioritizing an expeditious probable cause determination with the need to protect the public from those deemed likely to be a danger to others and to commit sex offenses if not confined to a secure treatment facility. Mental Hygiene Law Section 10.03, e. Thus, petitioner has failed to sustain his burden to demonstrate the statute's facial unconstitutionality. 4. In addition to his facial challenge, petitioner contends that Mental Hygiene Law Section 10.11, d. 4, violated procedural due process as applied to him. His contention that delay beyond the 30-day statutory window contributed to a due process violation is unpreserved for our review, because it was not raised in his petition or before Supreme Court. His remaining arguments, to the extent preserved, are unavailing. Accordingly, the order of the Appellate Division should be affirmed, without costs. Order affirmed, without costs. Opinion by Judge Singas. Judges Garcia, Canataro, Troutman and Halligan concur. Judge Rivera dissents in an opinion, in which Chief Judge Wilson concurs. Decided October 22, 2024.
Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law